Okay, so today we're discussing the patient privacy implications of the IMS case currently before the Supreme Court. The 3 New England states have passed bans on the selling and use of prescriber data for the purpose of customized detailing of doctors. And by detailing, I mean the personal visits that pharmaceutical companies pay to doctors to discuss and market their products, which is the practice of the pharmaceutical reps to customize their presentations using profiles about the prescribing histories of the doctors that they visit. So under the belief that these practices are insidious, New Hampshire, Maine, and Vermont have each attempted to intervene through legislation. So the statutes don't actually ban detailing, but they ban the use of prescriber data to customize the detailing. So the laws target a form of behavioral advertising. So we'll expect a ruling from the Supreme Court at the end of the month, probably the 26th or the 29th. But the case is quite complex, and the implications on patient privacy are only one of the many issues that the court might end up opining on. So my role in this webinar is to orient the non-lawyer audience, especially with some of the bigger picture First Amendment issues, and then also provide some background on the more specific question that we're here to discuss today, which is whether current de-identification practices that are in place right now are too weak to protect patient privacy. Okay, so let me first define what this prescriber data is and how we get it. When patients get their prescriptions filled at pharmacies, the information from their prescriptions usually gets transmitted to one of the data aggregators like IMS Health. So the pharmacies are covered by HIPAA, and all the data that has to be de-identified with respect to the patients before it leaves their control or the control of their business associate data aggregators. So I'll describe what HIPAA requires in just a minute. But the data is then sold to these pharmaceutical companies for the detailing practices that I described. And these repositories are also where health and academic researchers go to get prescription-related data, too. All right, so HIPAA requires, HIPAA, the Health Insurance Portability and Accountability Act, that is, requires covered entities, including pharmacies, to de-identify protected health information before releasing it to others. So to be considered de-identified, the entity has 2 options. The safe harbor method of de-identification requires them to remove 17 specific categories of information that are often traceable to identities: names, obviously, social security numbers, telephone numbers, addresses, except that the first 3 digits of the zip code are okay for release. And then the 18th category of information that has to be stripped is anything else that might identify the patient. And after doing this, if the entity still has knowledge that a patient can be re-identified somehow, then it still will not be considered de-identified until they address the issue. The other method requires the entity to enlist the help of a statistician who has to conclude that the methods used to de-identify the data are sufficiently good that the chance that somebody is going to be able to be re-identified is, quote, very small. The statistician has to document his methods and also his results after applying the methodology. So if you want to see the specific HIPAA regulation language, the last 3 slides of this presentation give the regulatory language, but I'll let you browse that at your leisure. Okay, so the example of PI data from the record of the IMS Health case it suggests that the data sets usually include identified information about the prescriber and the pharmacy, and then contain only limited information about the patients themselves. Age and gender were the only variables that appeared in the factual record, and as far as I know, this is not an issue for dispute between the parties, so this is probably a good example of what this PI data realistically looks like. Okay, so the Vermont statute was struck down by the Second Circuit for violating the First Amendment, but the Maine and New Hampshire statutes survived constitutional review over in the First Circuit. And the statutes have slight variations, although ultimately they're probably all going to have the same fate. Whatever the Supreme Court decides will probably end up determining the fate of all 3 statutes. The Vermont statute, which I quote in part here, prohibits the transfer or use of the PI data if it's going to be used for customized detailing, unless the doctor consents to have it used in this way. So it's equivalent to an opt-in system. The doctor can opt into allowing the data to be used. New Hampshire statute appears to be the most restrictive on speech because there isn't a consent exception, and it also prohibits the use of PI data even for assessing the effectiveness of pharmaceutical marketing strategies. Maine statute requires the doctors to affirmatively opt out of the data collection and use process. Okay, so the first question is whether this prescription data, the transfer of this data, is speech at all. So remarkably, the 3-judge panel on the First Circuit decided that this raw data, the transfer of raw data like this, is not speech, but merely an information commodity, which they say should be treated no differently from regulating beef jerky or any other good. The Second Circuit disagreed because even dry information gets First Amendment protection. And I'd be really surprised if the Supreme Court disagreed with the Second Circuit on this. The First Circuit was getting wrapped up in a pair of cases that was struggling to decide whether software code is speech or not because it sort of has qualities of both speech and a product. But in the context of prescription data, the collections of facts usually aren't considered to have this dual quality. So the Second Circuit also rejected IMS's argument that the Vermont Statute should be reviewed under the highest level of scrutiny, strict scrutiny review, rather than the lower standard that's afforded to the commercial speech. So even though detailing visits often provide information about side effects and other research results, the primary purpose of using the PI data for these customized detailing is to sell the pharmaceutical products. So the Second Circuit was determined to apply the commercial speech standard. And the Supreme Court, based on its oral arguments, looks like it's going to do the same thing. So the central Hudson test governs the protection for commercial speech. And it first asks whether the regulation aims to protect a substantial government interest. So the state of Vermont's stated purposes were to protect the privacy of prescribers, that is the doctors, and then also to contain medical costs and to promote public health. So the Second Circuit found that the doctor privacy issue failed at the very first question because the statutory scheme didn't actually limit the flow of this information much at all. A newspaper or a public interest group or even a nosy person could access this information and do whatever they wanted with it. And so the other two interests for medical costs and public health survived the first question, but ended up failing on the second and third because the court found that whatever ills the state was trying to treat could have been done more directly and without implicating speech. So, for example, if the state thought that generic alternatives should be tried first if they exist, then they could require that or at least incentivize that rather than inhibiting speech. Okay, so the state did not and has not overtly emphasized a state interest in patient privacy. But it has become one of the major points of interest in this case. The New York Times and the Concurring Opinions blog and others have characterized the IMS case as testing the court's faith in current de-identification processes. So Vermont had explicitly listed patient confidentiality as a state interest being protected by the law. The Second Circuit probably would have rejected it for the same reason that it rejected the interest in prescriber privacy, because the statute doesn't actually prohibit widespread dissemination of this data. And sure enough, there is a line in the opinion essentially saying that. The concern with patient information that can be gleaned from PI data isn't reduced in any way by this statute because it doesn't prohibit further dissemination. But in a footnote, the dissenting opinion seemed to take up this issue. So the dissenting judge, while she didn't go so far as to say that patients could be re-identified, she suggested that this type of information is sort of creepy. Other amici briefs have gone so far as to say that this PI data can be used to re-identify actual patients. So multiple amici briefs make this claim. The EFF and EPIC briefs probably make it the most overtly. So the Electronic Frontier Foundation brief makes a claim that in the information age, no data should really be considered sufficiently de-identified because as more and more information becomes available, we're better able to re-identify, an intruder, that is better able to re-identify somebody. And the EPIC brief cites heavily to the work of LaTanya Sweeney, and both briefs suggest that performing de-identification is no different from just removing names and direct identifiers and then calling it a day and releasing the data. So the briefs don't actually bother to distinguish between de-identification practices that predated HIPAA and didn't really do hard work in figuring out what the risk was, to the sort of data that's prepared for research dissemination today under HIPAA regulations. The EPIC and EFF briefs also rely on some inapplicable examples, like the re-identification of someone in the AOL search query database. And that data was incompetently de-identified. In fact, I'm not even sure it's fair to say that it was de-identified at all, since it included last names and addresses. And then they also rely on a law review article by Paul Ohm that asserts that as more and more information becomes available, re-identification will inevitably become very easy. These briefs and Ohm's article don't appreciate how difficult it is for an intruder to match the identified data to identities and to have confidence in those matches. And the three of us were motivated to contribute to the debate because we each independently noticed these oversights and were eager to correct the record and show that this is not actually as easy as some of these briefs suggest. So with that, I will pass the baton on to Dan. And my contact information is here. I'd be curious to hear, especially from the attorneys working on the brief, if you have any comments.
Okay, thank you, Jane. So now we'll turn it over to Dan.
Thank you, Khaled. Okay, today I'm going to be giving you an overview of how we can understand re-identification risks, and in particular, those as controlled by HIPAA-specified de-identification methods. And so I would like to start just by speaking briefly to the value of de-identification. Properly de-identified health information is really an extremely valuable public good. And having the broad availability of de-identified data is an essential tool for supporting scientific innovations and health system improvements, and has been an important engine which has driven forward innumerable health system improvements. These have included things like quality improvement efforts, health systems planning, fraud detection, medical research, public health research. So there are a whole variety of activities that routinely take place using de-identified data, and these have been very important to both health systems improvements that we have already achieved and to improvements that we anticipate will increase as we get a richer set of clinical data that has been de-identified from electronic health records, and as the nation's health IT effort moves forward. Unfortunately, there's one of these inconvenient truth situations that we face. We can have either information that has poor privacy protections, or we can have information that's, and therefore good information quality because of all the information that is included, or we can have very strong disclosure protections, which, for example, would be not releasing the data at all. But we're always faced with a trade-off. We can't have the optimal situation with regard to both. And while I think we can quite often achieve very reasonable balances and trade-offs between these two issues of privacy protection and information quality, it's not possible to have it both ways simultaneously. So this leads to some misconceptions about properly de-identified HIPAA information. The Paul Ohm paper, which I would recommend people to read, tries to make the case that indeed de-identification does not work because of easy, cheap, and powerful re-identification. And while I think it's clearly the case that one always has to take into account re-identification potential in trying to balance these equations of information quality and privacy protection, I would argue that indeed re-identification, when it's been properly implemented, is not at all easy. It's certainly not cheap, and the power of re-identification is subject to a couple of considerations that I'm going to bring forward. So the pre-HIPAA situation, it was been demonstrated both by LaTanya Sweeney, who estimated that about 87% of the U.S. population could be re-identified just on the basis of the 5-digit zip code, full date of birth, and gender. And then again by Felipe Goel, who estimated that about 63% of the population could be identified on the basis of these features. So clearly, pre-HIPAA, we have concern about high-resolution variables like birth dates or full 5-digit zip code, and particularly those things in combination. The reality now, though, is that under HIPAA-compliant de-identification, safe harbor re-identification risks have been reduced to the point where they're roughly about 4 in 1,000. And the estimate of efficacy for how much this protects over having direct access to PHI is somewhere in the range between, depending on state or region being considered, 400 to up to 2,500 times more protective than having that information directly exposed. So these are rather dramatic improvements. And the reality is that under these de-identification requirements that exist for HIPAA right now, conducting re-identification is an expensive and time-consuming task that requires some fairly serious computer and mathematical skills. It should be rarely successful if it's been conducted correctly. It should be rare that someone can be re-identified. And it is the case that data intruders who attempt re-identification would most often be uncertain as to whether they had actually succeeded. So I would say there's another potential misconception about HIPAA de-identified data, and that is that it works perfectly and permanently. So while I think we can't argue that it doesn't work at all, it's certainly not the case that data that has been de-identified can be affirmed to be perfectly protected from any case of re-identification. And it needs to be realized that because the pool of reasonably available information that could be used to aid someone trying to re-identify is likely to grow, that we shouldn't consider de-identified data once it's been claimed to be de-identified or determined to be de-identified under HIPAA, that condition should be expected to exist permanently going forward. That determination of de-identification needs to be constantly revisited against the issue of what information is reasonably available for re-identification. So another point here is that some of the more popular methods of attempting de-identification, like k-anonymity, in which you try and make sure there are always at least k observations, say 2 observations or 20 observations that all share the same characteristics, those types of approaches, unfortunately, come with implications for statistical accuracy and for the utility of the data. So in the process of trying to recode data so that indeed everyone shares similar values with someone else, it has impacts on the statistical accuracy and on the utility of the data, and can make it unsuitable for many statistical analyses if these issues of statistical accuracy and utility are not attended to. So another critical issue here that is part of the process of disclosure limitation science is that it is often the case that the process of trying to verify re-identification is never fully validated. And so it is quite common that scientists attempting to estimate risks of re-identification assume that there is a perfect population register available. This is virtually never tested, and if you've talked to anyone who's involved in issues of the accuracy of voter registration lists or the process of conducting the U.S. Census, they will clearly let you know how difficult it is to build a perfect population register. In addition to that, we have these issues of data divergence. A lot of variables that could be used to re-identify people are things that change, and so there are time dynamics in those variables. People's zip codes change when they move, their marital status changes when they get divorced or get married, etc. And often there is missing and incomplete data in both the data that is attempting to be re-identified and in the population register, and other keystroke or coding errors or inconsistencies occur that make it difficult to match that data with each other. Granted, there are probabilistic record linkage methods that can be used to try and overcome some of these data divergence issues, but these are subject to uncertainty, and so the data intruder using those kind of methods will never really be certain that the correct persons have been re-identified. There's a spectrum of identification risk that needs to be acknowledged. We draw a hard line and say this data is de-identified, but in reality, the spectrum ranges from fully identified data that includes things like names, addresses, social security numbers, limited data sets, which are not considered to be de-identified under HIPAA, but certainly have all of the usual direct identifiers, things that can be used in a one-time lookup against reasonably available information to identify people. Those have been removed. And then we have both safe harbor de-identification and statistical de-identification. The statistical de-identification conditions require that the risk needs to be very small, that the information could be used alone or in combination with other reasonably available information by the anticipated recipient to identify an individual in the data. And so statistical de-identification can be used to release some of the safe harbor data elements that are prohibited in that list of 18 data elements. And those include data that is of great value in many statistical and health research purposes, things like full date of service or geography type information. So disclosure risk analyses can be conducted to assess these risks of re-identification. And using those risk estimates, we can make a determination as to whether or not the risk of re-identification is very small. We have to anticipate, however, that there will be a continued rapid increase in publicly available data. And so information that is either a matter of public record or is reasonably available, say, through commercial data vendors, needs to be considered as reasonably available information that could be used for re-identification of individuals. The process of doing a reliable and sound de-identification process involves balancing two vitally important societal interests. One is protecting privacy, and that, of course, is of a critical importance. But equally important is the idea of preserving the utility and the accuracy of the statistical analyses that are performed with de-identified data. The issue here is that it is possible to destroy multivariate relationships or hide heterogeneity between various groups. And it can be the case that, indeed, if de-identification is not properly performed, not only will we miss the true situation that exists, but we may not even know that we have missed it because we don't know the impact of what the de-identification process has done to the statistical quality of the data. So limiting disclosure inevitably decreases the quality of the statistical information to some degree, but a good job of de-identifying makes sure that we have balanced these two concerns. I'm going to run through some vital or foundational re-identification concepts for you. The first is of record linkage, and the idea of linkage keys, and then the difference between sample uniques and population uniques and the role those play in re-identification, and then talk about some straightforward methods for controlling re-identification risks. These include reducing the resolution of various keys and increasing the reporting population sizes for the groups that we report in. So in record linkage, we have this situation where a population register, for example, perhaps a voter registration list, which contains identifiers for individuals, could be linked up against, for example, maybe the gender and the age in terms of the year of birth, or full date of birth if it existed in both data sets, and then against medical information, which would contain these quasi-identifiers that are used to do the matching, but also reveals additional medical data about the individual. And so these quasi-identifiers are fields that are used in combination. Any one of them might not identify an individual, but the combined coding for those characteristics may indeed uniquely identify an individual. These quasi-identifiers are, of course, subject to various key resolutions. So the difference between having a full date of birth and having a year of birth is fairly dramatic in terms of the number of values that are expressed in those two different codings. And quite often we can get by with year of birth or even coarser age coding, and that buys us a great deal of protection in terms of preventing re-identification risks. Similarly, geography can be an important tool in the process of re-identification. So when only one person exists with a particular set of characteristics in our sample data, we call that individual a sample unique. And likewise, if there's only one person in the larger population that has those characteristics, we would call that individual a population unique. And what we need to understand is in any healthcare data set that is being released, we have a certain number of observations that have unique sets of characteristics for individuals, and those would be matched up against a population record. Only a certain portion of those being unique with regard to those characteristics. So records that are not unique in the sample can't be unique in the population, and so those are not at any definitive risk of being re-identified. Records that are not in the sample also aren't at risk of being re-identified. Records that are unique in the sample but aren't unique in the population, so there might be one individual in the sample, but there are multiple people out in the population, can't be definitively matched to someone in the population with their identity. So finally, only those records that are unique in the sample and in the population are at clear risk of being re-identified with an exact linkage attack. We can determine the sample uniques very easily using the sample data, and for many characteristics, the likelihood of being unique in the population can be estimated well from statistical models using the U.S. Census data or other sources. Reducing disclosure risks, we have a number of avenues that can be used to attempt to do that, and they range widely in their statistical sophistication and complexity. Many of these are complicated to implement in constantly updated data sets or data streams. And so some of these more sophisticated disclosure control methods involve distorting the original data in order to protect against re-identification. And they can become quite complicated in large and constantly updated data sets. A basic solution involves, for example, doing something like reducing key resolution. So the key resolution can be reduced either by reducing the number of quasi-identifiers that are released, and so we restrict to the number of quasi-identifier variables being reported, removing some of them if they're not important for the research purposes, or we can reduce the number of categories or values within a particular quasi-identifier, like reporting the year of birth rather than the complete birth date. Another easily implemented solution is to increase the reporting population sizes. And so, for example, the safe harbor provision involves reporting only on 3-digit zip codes that have populations of more than 20,000 individuals. So when we do this, risk analyses need to be performed to make sure that we've got a high enough population threshold that's supported for the combination of variables when we're doing this under the statistical de-identification provision. Using these larger population sizes reduces the probability of someone being population unique within the reporting area, so this helps to protect importantly. One thing that is important to understand is that some popular de-identification methods like K-anonymity can, when they're used unnecessarily, they can degrade the accuracy of multivariate statistical analyses like regression analyses or various data mining methods because they can distort variance-covariance matrices or they can mask heterogeneity in subgroups. And so, unfortunately, it is often the case that this can be undetectable to the analysts who are using data that has not been well de-identified. This is a problem that's well understood by statisticians and by most computer scientists, but it's not well recognized yet within the public policy arena. And so it's important to understand that poorly conducted de-identification can lead both to bad science and bad decisions. Putting these re-identification risks in context, we need to realize that the very small risk threshold can take into account the entire data release context, and that we should be accounting for who are the anticipated recipients, what technical, physical, and administrative safeguards and agreements do they have to help reassure that re-identification attempts will be unlikely, that if they occur, they will be detectable, and that if they occur, the results of those attempts will be unsuccessful. And we also have to account for the motivations, cost, and effort involved and the necessary skills involved in attempting a re-identification attempt. So de-identification offers very important solutions. They provide practical solutions for preserving both date and geographic information. De-identification provides an essential tool for scientific innovation, health system improvement, and increasing efficiency. And it really is the workhorse or the engine that drives innumerable amount of essential healthcare system improvements. So de-identifying data greatly benefits our society, and it also provides strong privacy protections to individuals. And if you have any follow-up questions that we're not able to take during this period, I'd be glad to communicate with you at these email addresses. Thank you.
Great. Thank you very much, Dan. So for the last component of our webinar today, I will talk a little bit about re-identification attacks and what we know about re-identification attacks that have actually occurred. This is relevant for the Sorrell case because it addresses one of the key arguments, or one of the arguments that have been made against the disclosure of de-identified data, as Jane had mentioned earlier on. So just to set the context, there have been claims made by various authors. Paul Ohm would be a good example, but there have been others as well who've made similar claims that there has been a failure of de-identification. And in support of that claim, they often cite, those authors often cite a number of examples demonstrating that de-identification has failed. Of course, such claim, as some of you may know, such claims have had an important influence on policy already, in particular with the FTC in terms of how they distinguish or don't distinguish between identifiable and de-identified data. So the intent here was really to understand whether those examples are good examples to support that claim or that argument, and whether there are other known examples that support or contradict that. It's an important point, and we really wanted to evaluate the evidence. So the bulk of my presentation will be a discussion of that evidence, and I think it's important for the arguments in the Sorrell case as well regarding the effectiveness of the identification. So in terms of just general implications, if the identification really did not work, then there would be, and if this was incorporated into policy or regulations or legislation, this would create less incentive to de-identify data. If it doesn't work, why do it? Which will result in more identifiable information being shared for whatever the purpose is, for research, public health, commercial purposes, and so on. And it'll be very hard to argue that sharing identified data is better than sharing the identified data from a privacy perspective. I mean, I think most observers would agree that this would be worse for privacy if people start sharing more identifiable information because of the belief that the identification doesn't work. The other implication, of course, would be that there'll be more reportable data breaches. So if the identified data is lost or stolen, one can make the case that this is not reportable because it's not personal information. However, if more identifiable data is out there, with the number of breaches that we're still seeing, more identifiable information will be lost or stolen, and that will be reported, and this will have an impact on public's trust. Actually, it's not only the public's trust that will be impacted. Just as a brief aside, we did a study with family doctors and about their willingness to disclose their patient information to public health, and stories about data breaches that they hear in the media was mentioned a number of times in focus groups as a reason why they're reluctant to share information with public health. So it's eroding trust of the providers as well as the public. And of course, if confidence in the identification is diluted, then one under existing frameworks, legal frameworks anyway, and ethics frameworks, one would have to obtain patient consent in order to use that data for secondary purposes. Of course, unless there are exceptions. The problem with obtaining consent is, of course, there are practical challenges to obtaining express individual consent from patients for large databases. And these practical constraints range from not being able to contact the patients in those databases after a certain amount of time has lapsed, not having an existing or a continuing relationship with the patients in order to ask them for consent, and potential of creating inadvertent harm by recontacting them about an incident that may have occurred some years in the past that they did not want to revisit. So there are practical constraints to obtaining consent. However, even if express consent was possible, 2 years ago we published a systematic review looking at the impact of consent in the context of prospective and retrospective research. And this article was published in JAMIA, and a summary of those results will be appearing in a book that we're publishing later in the summer. But the systematic review had two parts. The first part was a systematic review of systematic reviews for clinical trials, and there's an overwhelming amount of evidence showing that consenters and non-consenters differ in the context of clinical trials, and they differ on things like age, sex, race, marital status, educational level, socioeconomic status, health status, mortality, lifestyle factors, functioning. It was a review, a summary of systematic reviews. There's overwhelming evidence. This issue has been studied extensively. Consenters and non-consenters in prospective studies, clinical trials, do differ. For observational studies, there was also a significant number of primary studies demonstrating this type of essentially bias. So that's another consideration. If we move into a situation where it's obtaining consent is individual consent is becoming increasingly necessary, then we will run into the situation where we end up with having biased data sets, and then this brings up some of the issues of statistical validity that Dan was talking about. Okay, so let's look at the evidence then. Do we know that re-identification attacks are happening frequently and that they're demonstrating that the identification doesn't work? So we did a systematic review. This is a Prisma diagram, which is a standard for reporting systematic reviews, but essentially we started with about 1,500 articles, and through various screening and data abstraction phases, and screening legibility phases, and then data abstraction of the remaining 14 successful re-identification studies, we were able to produce a summary of what we know. So as far as we know from the published literature, there are 14 successful re-identification studies that have been published. We evaluated those 14 on 5 criteria. So whether health data was re-identified or not. We looked at the profession of the adversary to understand who is doing these re-identification attacks. The country of the adversary, to understand where this was happening. Whether the re-identification was verified. So verification is important because if you, let's say, match 2 databases and you claim that you've re-identified somebody, but without actually confirming this re-identification, it's not possible to know whether the re-identification was correct or not. So verification is important in order to have a credible re-identification attack. And the last criterion was whether proper de-identification of the data was done prior to the attack. And we basically used the 2 HIPAA standards, HIPAA privacy rule de-identification standards, as the basis for deciding whether de-identification was done properly or not. We use them as criteria. So even if the authors did not claim that they've used those standards, we still evaluated them against those standards to see whether an argument can be made that the de-identification was done properly. And just to note, we didn't look at risk assessment studies and so on because these don't actually re-identify individuals. We really were looking at re-identification attacks where a claim was made that individuals were re-identified. So the main conclusions, actually before the main conclusions, I'll just describe this 5-level model of identifiability, which I think is, we found very useful in terms of explaining what proper de-identification means. Level 1 is readily identifiable data, and level 5 would be aggregate data, which would essentially be summary data that's disclosed. We see a lot of masked data, or what we call masked data level 2, which is essentially data where the direct identifiers have been removed. So these would be the names and addresses and email addresses, photographs, biometrics. Masked data is not de-identified data because it is still possible to re-identify individuals from masked data. And a lot of the 14 studies, a good percentage of the 14 studies, the re-identification attacks were on masked data. Exposed data, which is level 3, is something that happens in practice, which is organizations or data custodians or covered entities that apply the identification to a data set without actually following a standard or being able to measure the re-identification risk. So it's more than masked in the sense that indirect identifiers or quasi-identifiers are manipulated, but without following a standard or without being able to measure the risk of identification, you really don't know whether you've done a good job or not. And this is still not, would not be considered de-identified data because, at least from our experience, when neither of these two things are done, when no standards are applied and no measurement is applied, in most cases the risk is still very high. It feels good, but the risk is still very high. So level 4 is essentially where we can start making credible claims about whether your data is de-identified. And the main criteria there, as I mentioned, standards and measurement. So now, in terms of the main findings from this review, well, first of all, the majority of the attacks do not involve health data. So only 6 out of the 14 involved health data. The other data sets were internet data, financial data, census data. Most of the adversaries were researchers. If they were not researchers, then they were journalists. So there are 2 re-identification attacks that involved journalists, but the remainder were by researchers. So researchers are, I guess, dangerous people, but there's no evidence that of malicious re-identification attacks. You can argue that malicious re-identification attacks wouldn't be published, but as far as we know, the vast majority were done by researchers, and a smaller percentage by the media, journalists and broadcasters. Most re-identification attacks were conducted in the U.S. This is not surprising, given there are more people working in this space in the U.S., and there's more availability of auxiliary data that can be used for identification attacks in the U.S. as well, compared to other jurisdictions. Encouragingly, most identification attacks were verified, in the sense that the individuals who were claimed to be identified were the authors checked that and confirmed that. Some of the most cited studies did not verify their re-identification attack. For example, the often cited Netflix study did not verify that the individuals who were re-identified were indeed, the records that were re-identified were indeed belonging to those individuals. But the vast majority of the 14 studies did. And most re-identified data were not properly de-identified. So only 2 out of the 14 actually the data that was re-identified could plausibly, using very relaxed standards or very relaxed assumptions, could plausibly be claimed to follow either of the 2 HIPAA standards. So this is really important, because re-identifying level 2 or level 3 data doesn't say anything about how hard it is to re-identify properly de-identified data or level 4 data. So 2 out of 14, the data was properly de-identified. One case was a data set from the British Census, and another case was the ONC study. So this was the only study that was re-identification attack on health data where the data was properly de-identified, in this case safe harbor, in advance. And in this particular case, 0.01% of the records could be correctly re-identified, at least based on the material that's been published so far. This really illustrates an earlier point, that real data is messy, has errors, population registries are often incomplete, and when you try to do real re-identification attacks, it is difficult. So the only re-identification attack on health data where the data was properly de-identified before found a very low risk, which is consistent with what one would expect. All the other ones, the remaining 5 re-identification attacks on health data, it would be very hard to make the claim that the data was properly de-identified in advance. Quickly, just to go through a few examples that are often cited as examples of successful re-identification attacks. The Group Insurance Commission in Massachusetts, this is the Governor Weld example. So this was pre-HIPAA, and the data had zip code and date of birth, would never pass the HIPAA standards. Netflix, the authors of the Netflix de-anonymization study make clear themselves they don't believe the data was de-identified before it was released. So this is not an example of re-identification of data that was properly de-identified, according to the authors themselves. AOL, it'll be very hard to make the case that the data was de-identified. It's very well known that a large percentage of the population do vanity searches where they enter their name into their search queries. So if you release a database with search queries without including any of the unique identifiers in the data set, it will be quite trivial to find the individuals, because they provide you with their names in most cases. So in many cases, it is also possible to determine the location of the individuals from their search queries. And there's a good amount of literature on that as well. So it's not really surprising that you can re-identify individuals from their search queries, and it'd be very hard to make the case that this was de-identified data. The Southern Illinoisian case, which is also sometimes cited, this case would not pass the HIPAA standard. It included 5-digit zip codes. And basically all the other examples follow similar pattern, where you go through them and you can easily determine that they would not pass the HIPAA standard. So in conclusion, the obvious conclusion, it seems somewhat obvious, is that if you do not de-identify data properly, then you can re-identify the data. However, if you do de-identify the data properly, it's very difficult to re-identify the data. And this is simply what the evidence shows. Therefore, making broad claims about the failure of de-identification, as did some of for example, the EPIC amicus brief in the Sorrell case, would be a very strong statement that would be hard to support with evidence. Just going back to the Sorrell case, just wanted to make a couple of quick points as well, when I think they're important. The first one is around the, if you read the EPIC amicus brief, there's a big section there on MD5 and how the MD5 hash function is weak. That is absolutely correct. So we did actually do collect information about this, and it turns out that the IMS and the organizations in questions don't actually use MD5. So in the context of this case, whether MD5 is weak or not is irrelevant, because that's not actually the hashing or encryption function that's being used to protect the data. So not a relevant issue, basically. And then also in the study that was cited extensively related to a reidentification attack done in the early 2000s on prescription record data. Again, without going into the details, just a simple statement which is further supported by other individuals involved in that study who we've spoken to and have published on this earlier in the decade. The prescription record reidentification assessment or reidentification risk assessment did not evaluate the false positives. They made some assumptions, for example, that patients and pharmacies have the same zip code. It's a big assumption, and there was no assessment of whether this assumption was correct or not, and to what extent this had an impact on the rate of individuals that are claimed to be identifiable. So I think the accuracy of some of those numbers can be questioned. Maybe the data is there, just not available, it's not published. We don't know whether any of those numbers are accurate or not. And that, again, was an important or big piece of the argument in that brief. So I'll leave it at that, and again, here's my contact information if you want more, if you have any questions. The systematic review that I just mentioned is under review now, and it's co-authored with my colleagues Elizabeth Jonker and Bradley Mailman, and it's hard to predict when it'll be published, but hopefully before the end of this year. And with that, I'll now open it to questions. So please enter your questions in the text box at the bottom, and I will read the questions, and then I will ask one of my co-presenters or myself will answer the questions as they come in. And given that we're running a bit late, we will keep on going for at least another 15 minutes to answer your questions. You can see a lot of people typing, so just wait for the questions to come in. Okay, the first question, other than marketing, is there any other purpose for re-identified information? Now, Dan, do you want to take that one?
I don't know whether the person posing the question meant re-identified or de-identified.
I think she might have meant re-identified. Like, what's the why might people re-identify this information? I think it's the question. You could presuppose, one, they want to perhaps impugn the quality of the de-identification. They have some kind of agenda with regard to trying to assert that this is not appropriate privacy control. So that would be what I would call a demonstration attack. Khaled's put together a number of scenarios about various re-identification motivations, perhaps the idea of a nosy neighbor. It's unlikely that they would come into possession of de-identified data, because quite often de-identified data is only released to people through data agreements anyhow in a matter of usual practice, although it could be posted on the internet. I'm not aware of any situations in which de-identified health data is being posted in that kind of form.
Okay. The second question, what are the causes and reasons, do you think, for so much suboptimal de-identification currently available? Why are people not doing good de-identification? And Dan, again, would you like to take that one?
What? I'm sorry, I missed that.
Okay.
Are you taking that question? I can if you'd like.
Yeah, please go ahead.
Okay. I think it's mostly a matter of extent of training and familiarity with the concepts. I think it's a lack of knowledge about what needs to be done in order to correctly de-identify. And I think that lack of knowledge comes both on the end of not realizing what things need to be done to control re-identification risks, but also I think we see a lot of poor de-identification that occurs where the data is over de-identified and we have an impact on the statistical accuracy without being able to quantify what those impacts are. So a balanced form of de-identification by someone who's properly trained would address both of those issues. Khaled, do you have anything to add?
Yeah, I think part of it also is the lack of standards. I mean, we mentioned the HIPAA standards, but they're still at a high level. I think there's a real need for more precise standards for health data, and in particular, what does very low mean? What is very low may not be one number. I mean, I think it has to be context dependent, but a definition of how to define very low in a way that's acceptable. So I think more can be done to make it easier for organizations to do the identification more effectively. I think we're getting there. I'll just do a plug for our webinar tomorrow. If you are interested, there's the Canadian Institute for Health Information and various other organizations have published a standard for secondary use, for identification for secondary use, and we're doing a webinar on that tomorrow. So that's one starting point anyway. So I'll leave it at that. The next question is, how effectively are healthcare providers or systems de-identifying data? Historically, they have had to do so for quality reporting purposes to external parties, but with EHRs and new sources of data, are they prepared for likely new uses for patient data? Does either of you want to take that one?
Most of my background comes from the education context, so I'm really going to leave the healthcare specific questions to the two of you.
Okay.
I would say that this is mixed. I'd say that there are some healthcare providers and systems that have a great deal of sophistication, and they make use of, there's a great wealth of literature there, and there's a growing body of expertise that specializes in this area. It's also important to note that there are National Institute of Health supported centers of excellence in this area, like IDASH, that are coming forward. So I'm optimistic that where there may be deficiencies among some providers, certainly the resources are coming together to make sure that this is consistently done in a sound and reliable fashion. Khaled?
I agree with you totally. I think I don't have anything to add to that. The next question was, could you please elaborate on the ONC study? For example, I think I heard that it was limited to a particular race or some other characteristic. Is that correct? And if so, how would that limit the generalizations of risk from that re-identification? And also, was the 0.01% verified? So I'll just give you a quick synopsis. Your first point is correct, that it was limited to a particular race. The intention there was to, as I understand it anyway, was to make it easier to re-identify, and because this was a particular minority group. So one can argue that this may have elevated the risk. The 0.01% was verified. They matched it with a commercial database and looked at whether whether the verification was correct, and then they verified it because they knew the correct answer as well. since this was part of a study, the correct answer was no, so they could check whether the matching was accurate or not. So this was a verified match. The next question is HHS/CMS aware of this research? It would seem to provide important counterbalance to the fears expressed by privacy advocates that seem to be coloring the policy debate and resulting regulations. Well, I think we're trying to get this information out as broadly as possible, and there are a number of other publications that have come out recently and are coming out of the remainder of the year addressing this issue. So I think the counterbalancing will start to occur now. This would be my projection. I don't know, do you have any, Dan or Jane, have any other comments on that?
Yeah, I'm aware of a number of papers that are in press, including yours, Khaled, that I think importantly address this information. And so I do expect before the end of the year there will be a lot of literature that's critically evaluated these concerns that will be coming forward.
Next question, are there published allowable re-identification risk levels? Well, I'll start off and then I'll pass it on to you. There are a lot of precedents that people have been de-identifying data for more than 2 decades in the context of the census and disclosure of data from the census. So there are a lot of precedents in terms of disclosure of census data, educational data, and even health data from federal departments. So that's one answer. But in terms of regulated or legislated risk levels, no. Although in a Canadian context, the regulators have also provided a lot of precedents in terms of very specific quantitative thresholds that they expect the risk levels they expect from data that's claimed to be de-identified.
And I would add to that one of the things that's complicated about the process of trying to publish a hard risk estimate and say it can't be higher than this is that the context of who the anticipated recipient is and how they are receiving that data and what information is reasonably available to them needs to be taken into account. And so in situations where you have data use agreements for de-identified data that essentially parallel the conditions involved in, for example, a limited data set agreement under HIPAA, you have a lot of additional protection there that helps to make sure that that data cannot be re-identified without someone having violated a contract and having consequences for those kind of outcomes. So I think that needs to be part of the context in determining what re-identification risk levels are appropriate. Are we releasing this to a researcher under a agreement that binds them to not re-identify and to perform other protections on the data similar to those that occur in the limited data set use agreement or not?
Okay. Next question. Could you please elaborate on the British study that also supposedly was HIPAA de-identified and yet was re-identified? What was the rate and were the re-identifications verified? So this was a study that was done by British researchers. They were matching records from the sample of anonymized records from the British Census against the General Household Survey. So it was a demonstration attack, basically. And they were able to verify their matches with the National Statistical Office to verify whether their linking of these two data sets was correct or not. The SAR has been studied extensively by SAR is a sample from the UK census, and that has been the risk from that data release has been studied extensively. And there's a lot of data on the re-identification risk from that file, so this would follow the statistical standard where a number of very well-known statisticians evaluated that, worked on it, and published risk levels and documented it.
Was the survey data that they were linking to identifiable data?
No, it was also de-identified to some extent, and therefore the matches they had to send the matches back to the National Statistical Office in order to or Office of National Statistics in order to determine whether the matches were correct or not.
Okay, so it might be an internal link. In order to get to an actual identity, it would be one of several links that would have to be made.
Yes, yes. So they didn't identify individuals, but they were still able to verify whether the matches were correct or not. The reporting of that study was not that great. We included it anyway because it's one of the very few reidentification attacks on data that was can be claimed that it was properly de-identified, which was the SAR. Although if one was to apply strict quality criteria on that, we probably not include it just because of the poor reporting on that study. So if you exclude that, then there's really only one reidentification attack left on properly de-identified data. But we wanted to be generous.
Right.
Next question, how much risk is posed by poorly de-identified publicly available data sets, for example, state healthcare databases? Are CMS and AHRQ datasets adequately de-identified? I'll let you guys take that one.
Okay, I'm glad to take that. To the extent of my knowledge and having reviewed these, I think that a lot of those datasets are reasonably well de-identified. Those that are not, I would not characterize as being well de-identified, are most often released only through data use agreements. And so they apparently qualify as limited data sets, and there are contractual constrictions on the people who are accessing those data sets in terms of not attempting re-identification, needing to provide appropriate safeguards for the use of that data, etc. So those data sets I would not, I don't think they claim, for example, in some cases to be de-identifying data sets. I think they claim to be limited data sets. But I think in general, publicly released data, while it does provide some potential for re-identification attacks, these are usually being monitored by those agencies, and they're also being released under contractual control restrictions.
And I have a forthcoming paper called Tragedy of Data Commons that attempts to distinguish between theoretical risks and realistic risks, which is similar to what Dan's doing now. That while improperly de-identified data poses theoretical risk, the realistic risk is controlled to a certain degree by who actually has access to this information. In the education context, which I'm more familiar with, there are tons of examples of poorly de-identified information that gets released to the public. So No Child Left Behind data, for example, and I go through some examples in the paper. So on the one hand, the theoretical risk is very high. On the other hand, we don't know of any true malicious use of this information other than researchers like myself pointing out that geez, this is not de-identified at all.
Okay. So, next question. HIPAA has direct guidance about personal information and de-identification in the form of standards. Must standards be developed by industry? By data category, employee, or finance, etc., and who's doing such work? So who's developing these standards? Is it being done by industry, or is anybody developing these detailed standards?
Yeah, so U.S. privacy legislation is a real patchwork. It does develop by industry, and as a result, if there's any legal protection as opposed to sort of self-regulation, if there's any formal legal protection, it does end up being developed industry at a time. So the regulators, if there's federal legislation, they usually appoint a department, HHS in the context of health, the Department of Education in the context of education, and the regulators end up drafting regulations that incorporate to a certain extent the context of the industry.
Dan, did you have anything to add to that?
No.
Okay. Next question. We are seeing quite an emergence of data registry research. Ultimately, do you see an ethical issue or risk of data selling by the main holders of the registry? Any concerns with the sale of data held by these registries that was originally collected for the purpose of research? I guess the quick answer would be if it's collected for research, then and disclosed for research, then there would be an IRB involved in the process that would approve the types of uses and disclosures, and I would be surprised if IRBs would allow the selling of data. If this was a commercial registry, then it depends on, I would say, on the conditions under which that registry obtained the data to start off with from the covered entity, and whether it was de-identified. I mean, if it was de-identified, then there would be no, at least, from a legislation perspective, no restriction on what the data can be done as long as the de-identification has been done properly. Jane, Dan, do you want to add to that?
Well, high-tech imposes this new prohibition on the sale of PHI, and so in order to escape that, assuming that there are no other existing restrictions that are involved in the process of that registry having been created, in order to go out, presumably because dates of service are so important, it could not come out under safe harbor. It would need to be statistically de-identified. And I think the person performing the determination, if it's now going out for purposes that are not research purposes, would be taking into account who the anticipated recipients are. And so usually there's a higher threshold that is put in place with regard to consideration of a very small risk, dependent on the context of how that data is coming out. So I don't have a great deal of concern about potential for abuse in this area. Certainly, if that turns out to be the case, it's something that policymakers would want to turn their attention to.
Yeah, I think the ethics are to some extent determined also by what was promised or what the reasons for collection in the first place were. There's actually a wrinkle in this IMS case that this question is reminding me of, which is that the state of Vermont is now arguing, or at least in oral arguments before the Supreme Court, they argued something slightly different and somewhat novel. They argued that because the government itself required prescriptions to be collected in the first place, the government should control the information or should be more involved in the control of this information. So it's an interesting question that I hope for a number of reasons the court doesn't end up going down that path, because the government is involved in the creation and production of a lot of information. If they could control all of it, that could be somewhat threatening for the purpose of data dissemination. But there is this issue that because the government is facilitating the collection and sort of involved in the creation of these giant data banks, that maybe we ought to be putting some sort of use restrictions on the data.
Okay, and only 2 questions left. So the next one was more on the ONC study. Was the 0.01% verified all the way to a named individual or just to a unique individual whose name remains unknown? There's a paper coming out on the ONC study at the Joint Statistical Meeting of the American Statistical Association later this month, actually. And that will provide more information about the study itself. So I would wait until those details are released by the authors of that study, and it should be happening very soon. I don't know the exact date, but it's the JSM is coming up later this month. And the last question: will you please make everyone's slides available to us? Yes, absolutely. The slides will be posted in the next couple of days, and you will receive an email when they are. And I think we'll close it at this. So first of all, thank you very much, Dan and Jane, for your time today. Really appreciate it. It was a very important topic, and I hope the attendees found it useful. If you have any questions to any of us, please send us an email. The email addresses are on the screen right now. And as I mentioned, we'll be sending the recording, posting the recording and the slides online in the next few days. And just a reminder, our lab here does conduct a regular series of webinars on issues related to privacy of health information and ethics. And you can go to our website and register. They're free, and usually we have 2 a month. Probably slow down over the summer, but 2 a month on issues somewhat related to what we covered today. So thank you very much for joining us, and I hope you found the presentation informative and useful. Dan and Jane, did you want to say something in closing?
Just thanks to the audience for their attention on this issue. I think there's a great deal at stake in the future of de-identified data. And I think almost everyone in our society has benefited importantly from de-identified data, even if they don't appreciate that that has occurred or understand that that's occurred. And we've also benefited from the fact that we get